Thank you, everyone. Please be seated. We are here today for several cases for oral argument. The case of J. Doe versus Polk County is hereby submitted without oral argument. Our first oral argument of the day is Waterloo Community School District versus Employers Mutual Casualty Company, and it looks like the parties are ready, and we will begin with Ms. Calland.
Thank you. Good morning. May it please the court, counsel. This case is about how to interpret an insurance policy. We say that the plain language of the policy requires EMC to pay for repairs both inside and outside the classroom that collapsed to both the damaged and undamaged areas of the school because the building code required Waterloo to make repairs both inside and outside the classroom that collapsed to both the damaged and undamaged areas of the school. Because of the collapse, Waterloo had to make the entire school safe. Waterloo's interpretation makes sense given the purpose of the ordinance and law provision in the policy and the expectations of a reasonable policy holder. We would like the court to put itself in the position of the tens of thousands of Iowans who own an old building. So an old commercial building, an old residential building, an old government building, like the 90-year-old school here. And if you are one of those tens of thousands of Iowans, what are you supposed to do? So first, like Waterloo, you might choose to pay extra to buy additional coverage for ordinance and law. And then secondly, you do what the building code tells you to do. So you open your building up for inspection by the building official. You make whatever repairs the building official asks you to make. You get your certificate of occupancy. And after that certificate of occupancy is issued, everything is grandfathered in. You do not need to go around poking holes in the walls looking for problems. You do not need to update vintage materials and construction methods. All of that is grandfathered in under the code. And if you follow all of those rules, you should be entitled to the additional ordinance and law coverage that you purchased, meaning that...
Question. Let's assume that the snowstorm had never happened. Wasn't the damage already there, or the dilapidation, wasn't it already occurring? Even if they didn't know it or not, wasn't it already there?
Yes. So the experts agree that that there was deterioration in the school. And I think essentially you're asking me whether the school was unsafe the week before the collapse. But the pre-existing code violation exclusion that's in the policy, the question that asks is whether or not Waterloo failed to comply with any laws prior to the collapse. And the answer to that question is no, which means that the exclusion does not apply. Waterloo did not fail to comply. Yes.
Yourself, was the school unsafe the week before? Factually, isn't that true, given the deterioration in the load-bearing walls throughout the building?
If you're asking me, knowing what I know now, would I have sent my child into the school the week before the collapse? Obviously not, and there's no way that Waterloo would have allowed the school to operate under those conditions. But again, that is not what the pre-existing code violation exclusion asks. That exclusion, which incidentally EMC has the burden to prove that the exclusion applies, that exclusion asks if Waterloo failed to comply with any law.
It was out of compliance. I mean, if a city inspector had opened up the walls and found the deterioration, they could have forced the school district to do something about it prior to the collapse. Isn't that correct?
Yes, they could have done so, but the code official did not, and that is the determinative factor under the code.
Doesn't it come down to, is it a violation, if it's a violation that nobody at that time had taken note of and done any enforcement against? Isn't that kind of the issue, at least under that provision?
So I don't know that it's an issue of that there was a violation. There was not a violation, meaning that the Waterloo...
They didn't look into it, and they had not observed one. But had they looked into it, that issue already existed, correct? And so wouldn't it behoove any old building owner to don't look, just go get that coverage?
The old building owners are, in fact, they're entitled to rely on the code officials to do their jobs. And so they have certain obligations under the code. They have obligations to make their buildings available for inspection. They get their certificate of occupancy, but then the code specifically says that they're allowed to continue to operate until they're told otherwise, essentially. So everything's grandfathered in, and you don't have the obligation. Everybody agrees here that you, in fact, do not have the obligation to go breaking holes in your walls to go look for issues.
Cases address that exclusion.
So the Deb Associates case is probably the case that's most on point here. I don't actually know if it's DEB Associates or Deb Associates, but that's a case out of New Jersey that we cite. And that case is actually extremely similar to this case. And that policy, it did involve a pre-existing code violation exclusion, which the court specifically said did not apply because this whole concept that the building was hypothetically unsafe at some point prior to the collapse or to the covered cause of loss. The court rejected that argument because even though the building in Deb was theoretically unsafe for days or weeks before the wall collapse, there were no code violations prior to the collapse because it was only after the collapse that the building lost its grandfathered status. That case they actually used that exclusion to support their interpretation of coverage to the undamaged portions of the building.
That this particular additional coverage is meant to, protect against the grandfathering situations. I just question whether this is really a grandfathering situation. It wasn't that it was okay with everybody to have a building with these walls that were crumbling. The fact is just nobody had discovered it yet, right? That's different from grandfathering, isn't it?
Well, I mean, so in Deb Associates, it was actually, once they did the investigations after, so in that case, there was a windstorm that damaged one floor of the building. And it turns out that when they did investigations after that all of the floors of the building had the same problem. It was a lack of angle irons.
One in that decision suggests that there had been an earlier a visit by the building inspector who noticed that problem, said, you fix this part right here, but didn't tell him to fix the rest of it. That'd be like in this case, if somebody had noticed the crumbling wall and said, fix just this section, but you don't have to fix anything else. So does that make Deb or DEB distinguishable?
I don't think so, Your Honor, because there were different things that were done to Lowell over time. There was additions to the school that were made in 2006. ENC actually sent folks to the building from time to time to look around and see what was going on. And so it's not like that building was not subject to any kind of...
They didn't discover or see any deterioration on the the middle layer of the load-bearing walls in our case today, but in Deb, it looked like they had looked at that issue of fastening the walls to the floors and sort of gave them a pass. Seems like that's a different case.
I actually, as I said, I think that you have a very similar situation here where you have folks that are looking at the building, the repairs are made, there's tuck pointing on the outside walls, there's whatever the repairs are. And it's only after the collapse occurs that the sort of magnitude of the problem is discovered at that point in time.
Additional coverage for an abrupt collapse?
To get the coverage for the areas the undamaged areas of the school outside the area of collapse. I think that the parties agree that the collapse additional coverage applies inside the classroom. Although an important point, too, is that ENC has also agreed that the ordinance and law additional coverage applies inside the area of collapse. So the conditions are met for ordinance and law coverage inside the area of collapse. No exclusions apply. So specifically, that pre-existing code violation exclusion, EMC's position is that it does not apply inside the area of collapse. The deterioration exclusion doesn't apply inside the area of collapse. But if it doesn't apply inside the area of collapse, it should not apply outside the area of collapse either, because the same conditions were present throughout the older part of the school. And so when they make that acknowledgement that that there was no pre-existing code violation inside the classroom, that there is no deterioration exclusion that applies inside the classroom, that should also mean that those exclusions do not apply outside the classroom to the undamaged portions of the school.
I mean, that makes sense to me. It covers, for heavy, the weight of snow and ice, and it says it'll cover even if the collapse was due to building decay, so long as the owner didn't already know about the decay. And there, if we're reading this as a whole, if the drafter of this policy knows how to specify a knowledge, when knowledge makes a difference. If we go to the exclusion for the ordinance and law provision, it doesn't speak to whether the violation is discovered or known or not. So how do we reconcile these?
Well, again, so the pre-existing code violation, they determined it did not apply inside of the classroom either. So if there's no pre-existing code violation inside, there wasn't one outside, that would exclude coverage. But in addition to that, this isn't what the school, we're not trying to insert some sort of a knowledge requirement that's not there. What the exclusion says is that it has to be a law that the Waterloo failed to comply with. So I think I'm coming back to the beginning of what we were talking about, which that there is actually no law with which the district failed to comply. They did what they were supposed to do. They got their certificate of occupancy.
Know they were out of compliance, but if the building code prohibits an unsafe building, and that includes you can't have deterioration of a load-bearing structure, is ignorance an excuse?
It's not that ignorance is an excuse. It's that the code official testified that even knowing what he knows now, he would still say that the district was in compliance with all of the code provisions prior to the collapse. He testified as to that, and it's not just some guy saying that either. The code says that he is the person who is responsible for interpreting and enforcing the code, and he says that there was no code violation prior to the collapse.
Guy that said you can't occupy the rest of the building even though it was unaffected by the collapsed roof.
And again, it's
Who gets to say what the law is? If it was unsafe the week before, they just didn't discover it, and now the week after the collapse, he's saying this is you can't occupy the building anymore because these walls have deteriorated. Isn't that a failure to comply with the code?
I mean, the code, when you look at the provision of the code that deals with unsafe buildings, it's talking a lot about what the code official determines, what the code official finds, and that's the thing that triggers the duty to make the repairs, is when the code official determines or finds that the building is unsafe. I'd like to reserve a little bit of time for rebuttal, but I would also briefly argue that there's the other problem with EMC's interpretation of the policy and the district court's interpretation of the policy is that it reads the damaged and undamaged provision out of the ordinance and law provision. That provision says that EMC must pay for the loss of the damaged and undamaged portion of the building. That's exactly what happened here. You have a classroom that collapsed. As a result of the collapse, the entire school was deemed unsafe, and the law requires Waterloo to make all necessary repairs everywhere in the building to make the school safe, which means that EMC has to pay for the loss of both damaged and undamaged areas that need to be repaired. Thank you very much.
5 minutes when they're done. I don't know if you knew that.
Sorry, I thought I had to reserve some of my 15 minutes. Oh, I apologize. I'm sorry. Well, gosh, I have 40 seconds left then. I'm happy to answer other questions, but
That wording, isn't that still subject to the exclusion if there was a violation and they failed to comply?
that exclusion. I mean, that exclusion is, there are cases that have said this, that the intent of that exclusion is to cover a delinquent policyholder who knows that they have some sort of a problem, and instead they just wait around and they don't fix it in the hopes that maybe they can push the cost off on their insurance company. Nobody is suggesting that that's the situation here.
Do you agree there are no fact questions precluding summary judgment?
In fact, we are requesting summary judgment to be entered in the district's favor. Thank you.
May it please the court, counsel. The district court's order granting EMC summary judgment and finding that coverage does not extend to remediation outside the area of the partial collapse must be affirmed by this court for 4 reasons. First, the partial collapse, which is the covered peril in this case, did not cause the need to remediate the age deterioration in other parts of the building under the applicable building codes. And I'll refer to that as my causation argument. Second, because the age deterioration constituted an unsafe condition that required remediation under the applicable building codes prior to the partial collapse, the exception in the ordinance or law additional coverage for pre-existing code violations applies to preclude coverage. And I'll call that the exception argument. Third, the policy contains exclusions for deterioration and continuous or repeated seepage or leakage of water over a period of time, which are the 2 purported causes of the age deterioration, and those exclusions apply to preclude coverage. I'll refer to that as the exclusions argument. And then the 4th and final argument is that the collapse exclusion applies to preclude coverage for the age deterioration, and the collapse additional coverage does not apply to restore that coverage, and I'll call that the collapse argument. It's important to note that if the court agrees with EMC on any one of these 4 arguments, then it must affirm the district court. Conversely, you have to agree with Waterloo and reject all of these arguments in order to reverse the district court. Now, I don't believe I'm probably going to have time to get through all of these 4 arguments this afternoon or this morning. And so what I'm going to do is begin with what I think is probably the most straightforward one, and that is the exceptions argument. Beginning with the insuring agreement, and I've taken the liberty of preparing a summary of the pertinent policy provisions as an exhibit for you. The insuring agreement's on the first page. And so in order to trigger coverage, we have to have direct physical loss to covered property at the premises that is caused by or resulting from a covered causal loss. And the policy defines a covered causal loss as direct physical loss unless it is accepted or limited elsewhere in the policy. So applying that language here, the district seeking coverage for this age deterioration in other parts of the building, we concede that that is direct physical loss. The mortar has changed in its condition. It has deteriorated. So then the question becomes,
So are you saying that that's covered under the collapse, or it's covered because of the snow?
well, let me answer your question with regards to the partial collapse, which I think is distinct from the other parts of the building. The partial collapse, I think, is covered because it's a direct physical loss, and if you read the collapse exclusion, there's an exception if the collapse is caused by a specified causal loss. And if we look at the definition of a specified causal loss, it includes the weight of snow and ice. And so that's what's happened here.
The additional collapse coverage with respect to the part that actually collapsed? Okay.
But I would say that that exclusion applies outside the area of partial collapse, because there has not been a partial collapse. Abrupt falling down, it doesn't meet the definition of collapse to begin with. All right, so going back to the exclusions argument and whether any of the exclusions apply, there are exclusions for both deterioration and also for continuous repeated or seepage, leakage of water over a period of 14 days or more. Those are the two purported causes of this age deterioration, so those exclusions would apply to preclude coverage. In the brief, I have cited cases from other jurisdictions where courts have applied exclusions to preclude coverage for under the ordinance or law additional coverage provision. That's the Houston Specialties case and the Point case, and I believe those are cited at page 50 of my brief. Waterloo, to try to get around these exclusions, makes what I would refer to as a concurrent causation argument. And they say, well, part of the reason that we have to remediate this age deterioration is the building code, and that should be covered under the ordinance or law additional coverage provision. This court should reject that argument for two reasons. First of all, under Iowa law, the efficient proximate cause doctrine applies to resolve questions of concurrent causation in first-party property insurance cases like this one here. If the court has any questions about that rule, I'd entertain questions right now. Hearing none, I'm going to move on.
Case for the proposition that in a property and casualty policy, if you have an excluded cause and also a covered cause, why wouldn't the insured get coverage?
Cite you the City of West Liberty case, but let me explain the reasoning for that rule. When we have third-party cases, those are liability cases, and so the focus is on whether the insured is liable in that particular case. And you can imagine in shotgun pleadings, oftentimes there's at least one count that would be a covered count. And we know that in a liability defense case, we have a duty to defend the entire case, even if only one of those counts is covered. And that makes sense because the focus is on a court's or on the insured's tort liability. But in a first-party case, the focus is on whether there has been some sort of direct physical loss caused by a covered causal loss. And you can imagine in causation scenarios, there almost always is going to be some potentially covered cause. And so what courts have done in the first-party case is they've applied the efficient proximate cause doctrine, where we look at the dominant cause. And if the dominant cause is covered, there's coverage. And if the dominant cause is excluded, we excluded. And that makes sense in a first-party property insurance case, because if you went the other way, the exclusions would never apply.
What's the dominant cause of this collapse?
Dominant cause of the partial collapse would be the weight of snow or ice. The only cause of the age deterioration is the deterioration itself. What we learned in the City of West Liberty case is that for the efficient proximate cause doctrine to apply, there must be at least two causes of damage. And like the squirrel in the City of West Liberty case, the duty to comply with the code here did not independently cause any damage.
In counsel's argument that no pre-existing code violation was inside the classroom, so it cannot apply to the older part of the building. Can you address that?
Well, let's take a look at the policy language. That is at page 2 of my handout, if I remember correctly. And what I'm referring to as the exception to the ordinance or law exclusion is in subpart 2. And it says, we will not pay any costs due to an ordinance or law that, and here's the first part, you were required to comply with before the loss, even when the building was undamaged. And that is in fact true here, because the City of Waterloo has adopted the International Existing Building Code, which requires you to make your building safe, and the International Property Maintenance Code, which requires the same thing. So the second part is, you failed to comply with. And here, nobody can argue that the age deterioration didn't exist prior to the partial collapse. It had been there for years.
Knowledge requirement on that?
What the district is trying to do is to insert that into the policy. So subpart B reads, you failed to comply with. They want it to read, you knew you failed to comply with. And I would submit that that's not an appropriate interpretation of the policy. In fact, it harkens me back to an analogy that Justice Mansfield made when I was up here arguing the City of West Liberty case. And if I recall it correctly, his analogy was this. If I tell my son to be home at 5 o'clock and he doesn't show up until 5:30, he's late. My son may offer some reasons as to why he was late. It doesn't change the fact that he's late. And I would submit that same analogy applies here.
Chief's question then, why does that not also then exclude coverage under the part that actually collapsed?
Because there is a covered cause of loss that triggers the enforcement. In other words, they're not seeking remediation of the age deterioration, they're seeking remediation of the bricks and mortar and everything else that has partially collapsed.
You don't need the ordinance coverage rider in order to recover for the part that actually collapsed. So the exclusion in the ordinance coverage rider doesn't matter either. That's what you're saying? Okay.
I would say, let me take that a step further. Let's say as a part of the repairs of the partial collapse, the building official said, I want you to change the configuration of the ceiling joist. One of the issues was whether those joists were mechanically connected to the masonry walls. So if that had happened here, that condition, the manner of attachment, had been grandfathered under the code previously. But if it was required to be changed as a part of the repairs, this exception here would not apply because it was not a pre-existing code violation. It had grandfathered status.
That interpretation, any kind of code violation that had been grandfathered, even if it's completely unrelated to whatever's caused the actual collapse, is covered under the ordinance and law provision, even if it's completely unrelated.
Well, let's talk about what grandfathered status means. Grandfathered status would be a situation where you had at one time built a building that complied with the code, and the codes have changed over time. And now that's no longer in compliance with the code, but we allow it to have grandfathered status because we don't, as code officials, require the citizens to upgrade a building every time there's a change in the code. If there is a building that was built that never complied with the code in the first place, that's a pre-existing violation. So that's the distinction I think that we have to make.
Under the provision, is it limited to grandfathered type of situations?
This exception would only apply to grandfathered situations. Or I mean, a grandfathered condition would not trigger this exception.
That you cited where there was a building that's no longer, it's not ADA compliant would be an example where you're not required to make the building ADA compliant until you actually do more work on it, and then you have to bring it into compliance. And that would be an example of those costs would be covered by the policy, is that if there were some catastrophic event that caused collapse of the building. Is that an example then?
Exactly right, and I think the case you're referring to, Your Honor, would be the CV Ice case. And that's the case that gave the hypothetical of the convenience store that is in operation and its bathrooms are non-ADA compliant. That is a grandfathered condition. It also doesn't have a sprinkler system, although it's required to do so under the code. That's the pre-existing violation. Now, if some car crashes into the convenience store and causes damage, and now we have to repair that damage, if doing those repairs triggers ADA compliance, that's something that the ordinance or law additional coverage would pay for. But what it would not pay for is to install a new sprinkler system because that's a pre-existing code violation.
What if we follow the DEB or the DEB case? Does that undermine your position?
distinguishable for 3 reasons, Your Honor. First of all, the angle irons that were at issue in that case, as I think you had mentioned earlier, those were grandfathered in. The code official was aware of them, but allowed that condition to continue. He only enforced it after the partial collapse. Second of all, Deb is distinguishable because, the angle iron, that involves the same code provision in the area of collapse versus remediation in other areas of the building. Here, the building codes draw a distinction between repairs and remediation of unsafe conditions in the building. And so the code official here, when he says that building's unsafe, he is enforcing provisions under the International Existing Building Code and the International Property Maintenance Code that are different from the repair provisions. And then finally, Deb is distinguishable because it doesn't address the application of exclusions. And we have the deterioration and the continuous repeated seepage exclusion here.
You did a notice of additional authority of the builder's case from the Sixth Circuit. Did that, I didn't see any reference in there to an ordinance and law provision. If that policy had the same ordinance and law provision you have here, would that have changed the outcome?
But, Your Honor, we cited that case because I thought it was authority that supported our position on the causation argument, which would be a separate issue. All right, I see my time is up. Thank you for the opportunity to present argument.
4 minutes.
Thank you. So I'd like to go back to the pre-existing code violation exclusion, because I think that seems to be where most of the concern is here. So I wanted to reiterate one of my points about how if that exclusion does not apply within the area of collapse, which EMC has conceded that it does not, and EMC has paid additional code compliance costs within the area of collapse.
A little bit, it sounds, your opposing counsel said that they didn't need that coverage because that was within a covered cause of loss. Was there additional coverage provided that relied on that ordinance and law provision within the area that was actually under the collapse?
Yes, I believe that there were code upgrades that were required within the area of collapse that were paid for, and that had to rely, I believe, on the ordinance and law coverage, I think my opposing counsel's point was that he said, well, it was the covered cause of loss that triggered the need to do the repairs within the area of collapse. But that's true throughout the building. It was the covered cause of loss, the collapse, that triggered the need for the Waterloo to do repairs throughout the whole building, including the undamaged portions of the building. You can follow the sequence. Actually, it's in EMC's brief. I believe it's at pages 36 to 37. But the gist of it is that the partial collapse made the building dangerous. Because it was dangerous, it was then deemed unsafe. And because it was deemed unsafe, that means that Waterloo had an obligation then to make the entire building safe. So there is this direct causal connection between the collapse and the need to make the code, to make the building safe under the code throughout both the damaged and the undamaged portions of the building.
Issue in a little bit more detail in this sense. I understand that the collapse revealed the issue with the deterioration in the mortar throughout the rest of the building, but I'm not sure the collapse caused the other issue. So I'm struggling with a little bit with your use of the word causation in that context. I mean, I could imagine, if they were repairing an outlet or something, and then that revealed deterioration inside the wall, I don't think we would say the outlet repair caused the unsafe condition. It just revealed something that was already there.
Concept of trigger might be more helpful potentially. The collapse is the thing that triggered the Waterloo's duty to make the repairs throughout the school. I don't know if that's a helpful concept, but that is how I would describe it, is that so you have the collapse, which is the thing that caused the building to be deemed dangerous and unsafe, and then that is the thing that triggered that the evidence of the deterioration is the thing that triggered Waterloo's responsibility then to make repairs throughout the building to make it safe. And I would note that,
Does the ordinance and law additional coverage require a separate causation, evidence of a separate causation to provide coverage?
is that it does not. That's one of the fights that we've had with EMC is whether there's a separate causation requirement inside the ordinance and law provision. EMC wrote 2 of their other additional coverages to have such a causation requirement. Other insurers have put that causation requirement into the ordinance and law provision. However, I don't actually think that the court needs to reach that point because of the strong causal connection that exists between the covered cause of loss, the collapse, and the changes that were made. EMC and the district court did not cite a single case that denied ordinance and law coverage when a covered loss revealed that the same condition that caused the covered loss existed in other parts of the building, and the code required that condition to be repaired everywhere it was found. This would be the first case where the court denied ordinance and law coverage under those circumstances.
Not really a case directly on point. That's either way. That's why, you know, we have it and we're trying to figure it out.
The Deb Associates case, I think, is awfully close. It's got a very similar policy, and the requirement there was that there was coverage in both the damaged and the undamaged portions of the building. Thank you.
Waterloo Community School District versus Employers Mutual Casualty is hereby submitted. Court will take